Hey guys, welcome back. I really hope you are having a wonderful day or a wonderful night, which is statistically speaking the far more likely scenario if you are here, getting comfortable, arranging yourself in whatever configuration your body has decided is optimal for the next several hours. Tonight we are going to talk about something that I find genuinely delightful, which is the specific phenomenon of things that were never supposed to last but somehow never went away. We are talking about medieval things, institutions, practices, laws, habits, physical structures, social arrangements that were created as temporary solutions to temporary problems in a world that no longer exists and that have survived, with varying degrees of dignity and varying degrees of awareness of their own absurdity, into the 21st century. Some of them you use every day without knowing it. Some of them govern your life in ways that would make a medieval lawyer feel right at home. Some of them are so thoroughly embedded in modern existence that removing them would require a level of collective effort that nobody has ever quite managed to organise. It is a story about human stubbornness, institutional inertia, and the specific comedy of a species that builds things meant to last a season and then finds itself, 800 years later, still maintaining them because nobody got around to stopping. But before we begin, if you enjoy what I do here, please subscribe. It would mean the world to me, and leave me a comment telling me where you're watching from and what time it is. I am always genuinely delighted to discover how far these videos travel. Right, let us go find the Middle Ages hiding in plain sight. Chapter 1. The University, an emergency measure that accidentally became civilization. You are in Bologna. The year is 1088, and the city is doing something that cities in the 11th century do not typically do, which is spontaneously generating an institution of higher learning. Not because someone planned it, not because a king or a pope or a wealthy patron decided that what the world needed was a university and set about building one, but because a specific combination of circumstances, a city with a tradition of legal scholarship, a growing demand for trained lawyers in an increasingly complex ecclesiastical and commercial world, a body of students who had travelled from all over Europe specifically to study Roman law and who needed some kind of organisational structure to manage their relationship with the city and its teachers, has produced something that nobody quite intended and nobody is entirely sure how to categorise. The University of Bologna, widely recognised as the oldest continuously operating university in the world, was, in its origins, less an institution than an improvised arrangement. Students had been coming to Bologna to study under specific masters of Roman law, and the relationship between these students, many of them adult men, already trained in other areas, often of higher social status than their teachers, and the city that housed them was producing the specific kind of friction that arises when a large number of outsiders with money and specific requirements descend on a community that was not expecting them. The students organised themselves into guilds, not because they were trying to create a university. The word itself, universitas, simply meant a corporation or guild in medieval Latin, and referred to the organised body of students rather than the institution as a whole. They organised because they needed leverage. They needed leverage over their landlords, who were charging them outrageous rents because they had nowhere else to go. They needed leverage over the city authorities, who could arrest or expel them for various offences. They needed leverage over the teachers themselves, who could be fined by the student guild if they arrived late to lectures, left the city without permission, or failed to cover the prescribed material within the academic year. This is, when you think about it, an extraordinary organisational arrangement. The students, the customers, in contemporary commercial language, ran the institution. The professors were employees who could be sanctioned by the people they were teaching. The whole thing was organised explicitly and openly as a mechanism for protecting the economic and legal interests of the student, body in a foreign city. It was not a seat of learning in any elevated or idealised sense. It was a trade guild for people who had travelled a long way to learn Roman law and were determined not to be taken advantage of while doing so. Nobody thought this arrangement was permanent. The students who organised it were organising it for the duration of their studies, after which they would return to wherever they had come from and apply their legal education to the careers that had motivated their journey. The teachers who submitted to its authority were doing so because they needed the students, and the students had organised effectively enough to impose terms. The city authorities who negotiated with the student guild were doing so as a practical management challenge, not as participants in the founding of an enduring institution. And yet, here we are, nearly 1,000 years later, and the University of Bologna is still there, still admitting students, still awarding degrees, still operating within the basic framework: students, teachers, examinations, credentials, that the medieval arrangement established, even if the specific power relationship between students and faculty has been somewhat adjusted in the intervening centuries. And around the world, replicating the Bologna model in ways that preserve its fundamental structure, while adapting its specific features, there are approximately 25,000 universities enrolling somewhere in the region of 200 million students. The university as a concept spread from Bologna with a speed that reflects how well it solved a genuine problem. Oxford appears in the historical record as an organised academic community in the late 12th century, apparently emerging partly when English students were expelled from Paris in 1167 and had to go somewhere. Cambridge appears shortly after Oxford, apparently when a group of scholars left Oxford following a dispute with the town. Paris developed its own university structure with a different organisational model from Bologna, one in which the masters rather than the students held institutional authority, which is the model that ultimately became more common. Salamanca, Padua, Naples, Prague, Vienna. Universities proliferated across medieval Europe with the enthusiasm of an idea whose time has come, filling a need that the existing institutions of the church and the court could not adequately meet. The specific features of the medieval university that survive into the present are worth identifying, because some of them are so familiar that their medieval origins are invisible. The academic year, divided into terms or semesters, with specific periods of teaching and examinations separated by vacation periods, follows a structure that medieval universities established partly around the liturgical calendar and partly around the practical necessities of students who needed to travel home during certain seasons. The academic degree, the bachelor's, the master's, the doctorate, are medieval creations reflecting a hierarchy of achievement within the guild structure that the early universities established. The doctoral dissertation, the extended piece of original scholarship that demonstrates the candidate's mastery of their field, is a direct descendant of the medieval disputatio, the formal academic argument that candidates were required to defend before a panel of masters. The academic gown, the robe and hood that graduates and faculty wear at graduation ceremonies, and that most people assume are simply ceremonial costumes with no functional origin, were the standard clothing of medieval scholars, who wore long dark robes because they were often members of minor religious orders or were associated with clerical life, and who wore hoods because it was cold in the unheated buildings where they studied. The specific colours that different institutions use for different disciplines, purple for law, green for medicine, blue for philosophy, are standardizations of colour coding systems that developed in medieval universities and have been maintained ever since, because once you have established a convention for a colour code, it turns out to be very difficult to persuade large numbers of people to change it. The lecture, the professor standing at the front of a room and talking, with students sitting in rows taking notes, is a medieval format that emerged from the specific, practical conditions of medieval education in which books were rare and expensive, and the primary mechanism for transmitting the content of a text to students was to have a master read it aloud and comment on it. Lectura means literally a reading, and the medieval lecture was exactly that, a reading aloud of a canonical text with the master's commentary and interpretation. Books are no longer rare or expensive. The lecture format has nevertheless persisted across 8 centuries of educational development through the printing press and the internet and every other transformation in information technology, because it solves certain pedagogical problems tolerably well, and because nobody has quite managed to convince enough people that replacing it is worth the effort. The university was never meant to be a permanent institution. It was a temporary organisational solution to a specific practical problem in a specific historical moment. That problem, how to organise the transmission of specialised knowledge from people who have it to people who need it, in a way that is credible, standardised and socially recognised, turns out to be a permanent problem, and the solution that a group of medieval law students in Bologna improvised to protect their interests in a foreign city turns out to have been adequate enough that nobody has replaced it in 1,000 years. Chapter 2. The Jury. 12 random people and a problem nobody solved. You're in a hall, not a comfortable hall. This is the 11th or 12th century, and comfort in public buildings is not yet anyone's primary architectural concern. There are benches and rushes on the floor, and the smell that comes with rushes on the floor after they have been there for a while, which is a smell that historians of the medieval period have correctly decided not to dwell on too extensively. At one end of the hall, a royal official is conducting some variety of legal proceeding, and the proceeding involves something that is, by the standards of the era, a relatively recent innovation. A group of local men who have been gathered specifically to provide testimony or judgment about a matter that the official cannot resolve on his own. These men are not judges, they are not lawyers, they are local landowners and freeholders who have been selected because they are presumed to know something about the specific matter under investigation, the ownership of a particular piece of land, the circumstances of a particular event, the character of the parties involved. They are there to provide local knowledge that the royal official lacks. In a world where record-keeping is minimal, travel is difficult, and the only reliable source of information about what actually happened in a given place is the people who were there. The jury, and it is recognizable as a jury, in its basic structure, even in these early medieval forms, was not invented as a mechanism for determining guilt or innocence in criminal cases. That specific function came later and developed gradually through a process that nobody planned. The jury was invented as a practical administrative tool for fact-finding, a way for royal government to gather reliable information about land, taxation, and local conditions from people who actually had that information. The Domesday Book of 1086, William the Conqueror's extraordinary census of England, compiled within 20 years of the Norman conquest, used juries of local witnesses to verify and provide the information that royal commissioners were recording. The jurors were not deciding anything in the judicial sense. They were testifying to facts that they knew from personal experience and local knowledge. The commission was gathering data, and local juries were the data collection mechanism. The transformation of this administrative fact-finding tool into the criminal trial jury, into the body of 12 randomly selected citizens who determine whether an accused person is guilty or innocent, happened gradually over the 12th and 13th centuries, driven by a specific crisis in English legal procedure. That crisis was caused by the Fourth Lateran Council of 1215, which prohibited clergy from participating in trials by ordeal, in which guilt or innocence was determined by having the accused undergo a physically dangerous test, with the interpretation of the result in the hands of a priest, had been the primary method of criminal trial for much of the early medieval period. The defendant might be required to walk on hot coals, or to carry a hot iron, or to be thrown into water that had been blessed by a priest. The results were interpreted with considerable flexibility by the officiating clergy. The prohibition on clerical participation effectively made trials by ordeal impossible, and left English courts with an urgent need for an alternative method of criminal trial. The jury, already existing in its administrative fact-finding form, was adapted to fill the gap. It was not the obvious solution. It was not the only possible solution. It was the available solution, the tool that was already in the room when the crisis arose, and it was extended from its existing function to cover a new one with the pragmatic flexibility that characterizes legal systems under pressure. Nobody thought this was a permanent arrangement. The jury trial was a response to a specific emergency created by a specific ecclesiastical decree, extended from an existing but different institution to fill a gap that the decree had created. It was a workaround, improvised under pressure, with all the characteristic features of an improvised workaround, functional enough to do the job, imperfect in ways that are immediately obvious, likely to be replaced by something better once the immediate pressure eased. The immediate pressure never quite eased. The jury system, once established in English criminal procedure, embedded itself in the legal and cultural landscape in ways that made it increasingly difficult to dislodge. It became associated with important constitutional values, with the right of accused persons to be judged by their peers, with the protection of individuals against the arbitrary power of the state, that gave it a significance far beyond its origins as an administrative convenience. By the time the Magna Carta was being drafted in 1215, coincidentally the same year as the Fourth Lateran Council, the right to judgment by one's peers was already being articulated as a fundamental element of English liberty. The 12-person jury, the specific number that has become standard in many jurisdictions, is itself of uncertain origin. Various theories exist: 12 apostles, 12 tribes of Israel, some connection to the duodecimal numbering systems of early medieval administration. The honest answer is that nobody is entirely sure why 12 became the standard, and the persistence of 12 across 8 centuries of legal development in countries that have otherwise transformed their legal systems comprehensively, is a reminder that once a specific number becomes embedded in a legal standard, the bar for changing it is extraordinarily high. The jury in the 21st century looks, on the surface, quite different from its medieval predecessors. The random selection process is more rigorous. The rules of evidence that govern what jurors can hear are elaborate and carefully developed. The instructions that judges give to juries about the legal standards they must apply are the product of centuries of refinement. The right to trial by jury has been constitutionally protected in numerous countries, extended to civil as well as criminal matters in many jurisdictions, and debated, reformed and adjusted in countless ways across its 800-year history. But the fundamental structure, a group of ordinary people selected from the community, hearing the evidence and reaching a collective verdict, is the medieval structure. The problem it was improvised to solve in the 13th century. How do you determine the facts of a criminal case in a way that is legitimate and credible to the people involved? Turns out to be a permanent problem. The medieval solution, improvised under pressure when trials by ordeal became impossible, has proven adequate enough that no jurisdiction that has it has managed to replace it, despite periodic and continuing discussions about whether it could be done better. Chapter 3. The Common Law. The accidental legal system that conquered the world. You're in Westminster. The year is somewhere in the late 12th century, and the King's Courts, the royal judicial system that has been developing since the Norman conquest, are doing something that nobody specifically planned, which is accumulating precedents. Judges are deciding cases. The decisions are being recorded, imperfectly and incompletely at first, but with increasing regularity and increasing detail as the decades pass. And the decisions that have been made in previous cases are beginning to influence the decisions being made in current cases, because the judges who are deciding current cases are the same judges who decided previous cases, or were trained by those judges, or have access to the records of those decisions and regard consistency as a virtue. Common law, the legal system based on judicial precedent, on the principle that decisions made in previous cases should guide decisions in similar future cases, was not invented by anyone. It emerged from the accumulation of judicial decisions in the royal courts of medieval England, gradually and without any guiding plan, over a period of centuries. No legislator decided to create a precedent-based legal system. No theorist developed the doctrine of stare decisis, the principle that courts should follow previously decided cases, and then persuaded the legal system to adopt it. It grew from the practice of judges who found consistency desirable and precedent useful, in a legal culture that valued continuity and regarded deviation from established practice as something that required justification. The system that emerged from this gradual accumulation was, by any objective measure, chaotic. Medieval common law was full of procedural technicalities of bewildering complexity, of forms of action that bore names from Norman French that even the lawyers using them did not always fully understand, of fictions, legal fictions, in the technical sense, that were used to extend the jurisdiction of one court over matters that technically fell within the jurisdiction of another court. The forms of action, the specific procedural categories through which legal claims had to be made, were rigid and unforgiving, and a mistake in choosing the correct form could be fatal to an otherwise valid claim. Nobody designed this system. It grew organically and without central direction from the accumulation of decisions and the development of practice in royal courts that were, at their origin, administrative instruments of royal government rather than the foundations of a legal system that would eventually govern, in one form or another, approximately 1/3 of the world's population. Because that is what happened. The common law that emerged from the medieval English royal courts spread, through the mechanism of British colonialism, to North America, Australia, New Zealand, India, and large parts of Africa and Asia. The United States, which fought a revolution to escape British political authority, retained the common law system because it was the legal system that the colonists knew, and because rebuilding an entire legal system from scratch in the middle of a revolution and its aftermath was more than anyone wanted to take on. Today, approximately 30% of the world's population lives in jurisdictions whose legal systems are based on or significantly influenced by the common law tradition that developed in medieval English royal courts. The specific features of common law that most clearly reflect its medieval origins are the doctrines and practices that seem, to people trained in civil law systems most peculiar. The trust, a legal concept that has no real equivalent in civil law systems, which allows property to be held by one person for the benefit of another, was a medieval invention, developed in the context of crusaders who needed a mechanism for managing their property while they were away at war, and who trusted their property to friends or family to hold on their behalf. The equity jurisdiction, the body of law developed by the Court of Chancery to address situations where the strict application of common law rules would produce unjust outcomes, is the institutionalized response to medieval complaints about common law's procedural rigidity, developed gradually and without any plan to create a separate legal system. The adversarial trial, in which two parties present opposing cases to a neutral judge or jury, rather than the judge taking an active role in investigating the facts, is a feature of common law systems that civil law systems have generally not adopted, and that reflects the medieval development of the jury as the fact-finding mechanism, with the judge's role, consequently, defined as more limited than in systems where judges investigate as well as adjudicate. The common law was a temporary arrangement in the sense that every legal system in its early stages is temporary, a set of practices that serve the current moment without any guarantee of their long-term suitability. The medieval lawyers and judges who were developing it were not thinking about 1600, let alone 2024. They were thinking about the case in front of them and the precedents that might guide its resolution. The system that emerged from their accumulated decisions has proven durable, not because anyone planned its durability, but because it was good enough at resolving disputes and legitimate enough in the eyes of the people subject to it that replacement never became more attractive than continuation. Chapter 4. The Mortgage. A temporary arrangement with a morbid name. You're a medieval landowner. This is, by the standards of the medieval period, a position of some privilege. You own land, which is the fundamental form of wealth in an agricultural economy, and the land generates income in the form of rent or agricultural production that sustains you and your household. But you have a problem. You need money, cash, liquid capital, for something that your land income alone cannot cover. Perhaps you're going on crusade. Perhaps you need to pay a ransom. Perhaps you're involved in a lawsuit that requires a substantial payment up front. Whatever the reason, you need money and you have land, and the question is how to convert one into the other without permanently losing the land. The solution that medieval lawyers devised for this problem is called a mortgage. The word comes from Old French, mortgage meaning dead pledge, and the morbidity of the terminology reflects the specific legal structure of the original arrangement. A mortgage in its medieval form was an arrangement in which you transferred your land to a lender as security for a loan. While the lender held the land, they collected the income from it. If you repaid the loan, the land was returned to you. If you did not repay the loan, the land stayed with the lender permanently. The dead in dead pledge refers, depending on which medieval jurist you ask, and they did not entirely agree, either to the fact that the land produces no benefit for the borrower, while the pledge is in effect, the pledge is dead to the borrower, or to the fact that if the borrower fails to repay, the pledge is dead to the lender as well as the borrower. The land is permanently forfeited and the debt is extinguished. Either way, the name reflects a specific medieval legal structure that was designed to solve a specific problem: how to use land as collateral for a loan in a society where land was the primary form of wealth, but where the church's prohibition on charging interest made straightforward lending difficult. The prohibition on usury, the charging of interest on loans, was one of the great practical constraints on medieval finance, and the mortgage was one of the most important workarounds that medieval lawyers developed to navigate it. Rather than lending money at interest, which was sinful, the lender took the land and collected its income. The income from the land was the lender's compensation for the loan, and it was structured as the use of property rather than as interest on a debt, which put it outside the technical prohibition on usury, even if the practical economic effect was similar. Nobody designed the mortgage as a permanent institution of modern finance. It was a workaround, an ingenious legal fiction designed to solve a practical problem created by theological constraints that no longer apply. The church no longer prohibits the charging of interest. The specific structure of the medieval mortgage, land held by the lender, income collected by the lender, has been modified almost beyond recognition in most modern mortgage arrangements, where the borrower retains possession and use of the property while the lender holds a security interest. The legal concept has been transformed, adapted, reformed, and adjusted across 8 centuries of financial development. And yet, the word remains. The mortgage, the dead pledge, is the document you sign when you buy a house. 800 years after medieval lawyers invented the term to describe a specific legal workaround for a theological prohibition, the word has outlasted the theological constraint it was designed to circumvent. It has outlasted the specific legal structure it originally described. It exists in the present as a linguistic fossil, a word whose etymology reveals a medieval origin that the modern financial instrument it names has long since moved beyond. The persistence of the word is a small thing, perhaps, but it is the kind of small thing that reveals the depth of medieval roots in modern institutions. When you sign a mortgage, you're using a word that a medieval French lawyer invented to describe a specific legal arrangement designed to avoid a specific ecclesiastical prohibition. The prohibition is gone. The arrangement has been transformed. The word is still there, carrying its morbid etymology through centuries of financial evolution, because language changes more slowly than law, and because nobody decided that replacing the word was worth the effort. Chapter 5. The parish, God's administrative unit that became everyone's administrative unit. You're in a village. The year is approximately 1100, and the village is small, a few dozen households, at most a few hundred people, clustered around the agricultural land that sustains them in the specific, intimate relationship between population and productive capacity that characterized medieval rural life. At the center of the village, or near enough to it, is a church. Not a cathedral. Cathedrals are for cities, for bishops, for the large-scale ceremonial apparatus of the institutional church. This is a parish church, which is to say a local church serving the local population in the local community, funded by the tithes that the local population is required to pay, and ministered to by a priest whose appointment is controlled by whoever holds the local lordship. The parish, the ecclesiastical unit consisting of a church, its priest, and the population that the church is responsible for, was the basic building block of medieval Christian organization. It was created, gradually and without any single founding moment, as the mechanism through which the church extended its reach from the cathedrals and monasteries, where institutional Christianity was concentrated, into the villages and rural communities where most of the population actually lived. The parish was how the church baptized, married, confessed, and buried the people of England. It was how tithes were collected, how moral supervision was exercised, how the sacramental life of ordinary Christians was organized and maintained. It was also, gradually and almost entirely without intending to, how England was administered. The transformation of the parish from an ecclesiastical unit into a unit of civil administration happened so gradually that contemporaries barely noticed it happening. It began with the practical reality that the parish was the only pre-existing administrative unit that covered the entire rural population. Every person in England was a member of a parish, in a way that they were not necessarily members of any other defined administrative unit. When the state needed to organise something at the local level, when it needed to collect taxes or maintain roads or care for the poor, the parish was there, ready to hand, with its existing boundaries and its existing roster of parishioners and its existing officer, the parish priest, who could be recruited into administrative service without creating any new institutional infrastructure. The poor laws of the Tudor period, specifically the Elizabethan Poor Law of 1601, which established the principle that each parish was responsible for the relief of its own poor, made the parish an explicit unit of civil administration in a way that it had previously been only implicitly. The parish overseers of the poor, the parish surveyors of the highways, the parish constables, these were offices that were not ecclesiastical, but were organised through the parish structure because the parish was the available organising framework. The church wardens who had managed the physical and financial affairs of the medieval parish church became, by extension and gradual accumulation of function, the managers of a range of civil functions that the church wardens of 1100 would not have recognised as part of their job. The parish system survived the Reformation, the dissolution of the monasteries, the abolition of papal authority, the transformation of the Church of England into something that the medieval church would barely have recognised, because it was too deeply embedded in the administrative fabric of English life to be removed. Reforming the church was possible. Abolishing the parish as the basic unit of local administration and replacing it with something else, would have required rebuilding the infrastructure of local government from the ground up, and nobody wanted to do that while simultaneously managing a religious revolution. By the 19th century, the parish had accumulated so many civil functions that the ecclesiastical origin of the unit was almost incidental to its administrative reality. The civil registration of births, marriages, and deaths, transferred from the church to the state in 1837, was transferred from a system organised by parishes to a new system of civil registration districts that were, in many cases, simply the old parishes under a different name. The Poor Law Amendment Act of 1834, which reorganised poor relief from a parish basis to a union basis, had to work around the existing parish infrastructure because the parish boundaries were so thoroughly embedded in the landscape, the records, and the practical knowledge of local communities that replacing them wholesale was not practical. The word parish still appears in English civil life in ways that reveal its medieval ecclesiastical origins. Civil parishes, administrative units of local government in England, still exist as the lowest tier of the local government hierarchy, with their own councils and their own limited administrative functions. Their boundaries in many cases still follow the medieval parish boundaries established in the 11th or 12th centuries, because boundaries once established tend to persist, long after the reasons for their specific location have been forgotten. Chapter 6. The English longbow and the law that still technically requires you to practice it. You are in a field outside an English village. The year is 1363, and you are not there because you want to be exactly. You're there because you are legally required to be. The Statute of Winchester of 1285 and the subsequent archery statutes that have reinforced and extended its provisions require every able-bodied English male between the ages of 15 and 60 to practice archery on Sundays and feast days. The butts, the earthen targets against which this obligatory practice is conducted, are a feature of every English village, and the maintenance of archery skills across the male population is a deliberate policy of the English Crown, motivated by the specific military advantages that a population of trained archers has demonstrated in recent continental warfare. The English longbow was a military technology of extraordinary effectiveness in its specific historical context. The battles of Crécy in 1346, Poitiers in 1356, and Agincourt in 1415 demonstrated that massed formations of trained English longbowmen could defeat much larger armies of French knights, defeating the dominant military technology of the era through the combination of range, rate of fire, and the specific physics of a war arrow, striking an armoured knight at the velocity that a trained longbowman could generate. The training required to produce this military effectiveness was considerable. The longbow required years of practice to use effectively, and the evidence of this, in the form of skeletal remains from medieval England, that show marked bone deformation in the left arm and shoulder of individuals who had spent years drawing the bow, is literally written in the bones of the men who trained with it. The mandatory archery practice of the archery statutes was not theatrical. It was a serious attempt to maintain, across the general male population, the specific physical skills that the military effectiveness of the English army depended on. The archery statutes were temporary measures in the sense that they were created to address specific military circumstances, the need for trained archers in the armies that were fighting the 100 Years' War, and were tied to those circumstances in obvious ways. When the military circumstances changed, when firearms made the longbow obsolete as a military weapon, which happened gradually through the 16th century, the military rationale for mandatory archery practice disappeared. The statutes should, logically, have been repealed when their rationale disappeared. They were not repealed. They were not enforced after the 16th century. The last recorded prosecution for failure to practice archery appears to be in the Tudor period, after which the statutes were ignored rather than enforced. But they were not formally repealed, because nobody got around to it, and because the machinery of parliamentary legislation that would have been required to repeal them was occupied with more pressing matters. The result is one of the more charming examples of legislative persistence in English legal history. The Unlawful Games Act of 1541, which prohibited various games on the grounds that they distracted men from archery practice, was on the statute books of England and Wales until 1845, when it was finally repealed. Various archery statutes persisted longer. The specific obligation to practice archery, in various forms and with various qualifications, remained technically on the books in some form until the Statute Law Revision Acts of the 19th and 20th centuries began the systematic process of clearing obsolete legislation from the statute books. The butts, The earthen archery targets that the archery statutes required every village to maintain left a physical mark on the English landscape that persists to this day. Place names incorporating the word butts. Butts Lane, the Butts Road, appear in villages and towns across England, marking the locations where the mandatory archery practice of the medieval statutes was once conducted long after both the practice and the legal obligation have been forgotten by the communities that still use the names. The story of the archery statutes is, in miniature, the story of a great many medieval temporary measures. They were created for a specific purpose, in a specific historical context, with specific military or administrative requirements driving their creation. When the purpose disappeared and the context changed, they were not replaced with something better. They were simply forgotten, left on the books, unenforced and unobserved, until someone eventually got around to the housekeeping task of removing them. The housekeeping task, in the case of English statute law, has been ongoing since the 19th century and is still not complete. Chapter 7. The Guilds, medieval labour unions that never quite went away. You're in a workshop. The year is 1250, and the workshop belongs to a master craftsman, a goldsmith, let us say, in a prosperous town of northern Europe. The workshop is busy. The master is working. His journeymen, trained craftsmen who have completed their apprenticeship but have not yet achieved the status of master, are working alongside him. One or two apprentices are watching, learning, doing the simpler tasks that do not yet require the full skill they are in the process of acquiring. The hierarchy of the workshop is clear and structured, and the structure is maintained by an institution that governs essentially every aspect of the crafts practice in this town. The guild, the merchant or craft guild, the organised association of practitioners of a specific trade or craft, was one of the most pervasive and most powerful institutions of medieval urban life. Guilds controlled who could practice a craft in a given town, how long the training period for that craft would last, what standards of quality the products of the craft had to meet, how disputes between guild members would be resolved, what prices could be charged for guild products, and a vast range of other aspects of economic life that would, in a modern economy, be governed by either market forces or government regulation. The guild was not designed as a permanent institution. It was designed, insofar as it was designed at all, rather than growing organically from the practical needs of craftsmen organising for mutual protection, to solve specific problems. The problems of quality control in a market where buyers had limited ability to assess the quality of complex craft products before purchase. The problems of training and skill transmission in a world where craft knowledge was primarily passed from master to apprentice, and maintaining the quality of that transmission required organisational oversight. The problems of economic security in a world where unregulated competition could drive down wages and working conditions to levels that made skilled craft practice unsustainable. These are not temporary problems. They are recurring features of economic life in every era, and the guild's solutions to them, credentialing, apprenticeship, quality standards, collective economic bargaining, are not temporary solutions. They are solutions whose fundamental logic persists into the present in forms that are recognisably descended from the medieval guild tradition, even when they do not use the word guild and do not trace their origins to it. The professional licensing system that governs medicine, law, engineering, and dozens of other professions in modern economies is, in its fundamental structure, a guild system. The requirement that practitioners of a profession hold a license, that the license be granted by a body controlled by existing practitioners, that the license be contingent on completing a specified training program and passing specified examinations, that unlicensed practice of the profession be prohibited. All of this is guild logic, applied to modern professions through mechanisms that were shaped by the medieval guild tradition even when they were not directly inherited from it. The apprenticeship system, the formal training arrangement in which a young person learns a trade or craft by working under the supervision of an experienced practitioner, receiving training in exchange for labour, is a medieval guild invention that has survived, in various forms and with various modifications, into the present. Modern apprenticeship programs in construction, manufacturing, and various skilled trades are direct descendants of the guild apprenticeship, maintaining the basic structure, defined training period, supervised practice, formal completion credential that medieval guilds established. The trade union, the organised association of workers in a specific trade or industry, bargaining collectively with employers over wages and working conditions, is the direct institutional descendant of the journeymen's associations that developed within and alongside the medieval guild structure. The journeymen, the trained workers who had completed their apprenticeship but could not afford to establish their own workshops and become masters, organised separately from the masters, representing their specific interests in the labour market, in ways that the master-dominated guild structure did not adequately protect. The specific mechanisms of collective bargaining, of the strike, of the closed shop, all of these have medieval antecedents in the practices of journeymen's associations that medieval guilds struggled, with limited success, to suppress or control. The guild is not, strictly speaking, a medieval thing that survived unchanged. The formal guild system, with its monopoly privileges, its control over who could practice a craft in a given town, its hierarchical structure of apprentice, journeyman and master, was largely dismantled in the 18th and 19th centuries, in Britain by the repeal of the Statute of Artificers in 1814, and in other European countries by similar reform legislation. The specific institution did not survive, but the logic survived, and the specific institutional forms that the logic generated, professional licensing, credentialing bodies, apprenticeship programs, trade unions, quality standards organizations, are present in the modern economy in ways that reflect the medieval guild's influence more than they reflect any subsequent invention. The guild was a temporary arrangement for managing specific economic problems. The economic problems were not temporary. The solutions that the guild developed were adequate enough that they were adapted and continued in new institutional forms long after the guild itself had been abolished. Chapter 8. The Coroner, Death's Accountant Who Never Retired. You're in a village in rural England. The year is 1194 and something inconvenient has happened. A body has been found. A man dead under circumstances that are not entirely clear, lying in a ditch at the edge of the village common. This is problematic for several reasons. The most immediate practical problem is not the moral or spiritual one, though those are real and will be addressed by the appropriate ecclesiastical authorities in due course. The most immediate practical problem is financial, because in the England of 1194, an unexplained death has financial consequences that descend on the community in which it occurs with a heaviness that concentrates the local mind wonderfully. The deodand, the legal principle that an object that causes a person's death belongs to the crown as an act of expiation, means that if this man was killed by, say, a cart, the cart belongs to the king. The murdrum fine, the collective penalty imposed on a community where a Norman was found murdered, dating from the conquest and extended over time, means that if this death is a homicide, the community may owe a substantial payment to the crown. And the various other financial consequences of violent or sudden death that the royal fiscal machinery has developed over the past century and a half mean that the crown has a strong financial interest in exactly what happened to this person, how, and under what circumstances. Enter the coroner. The office of coroner was established in 1194 by the Articles of Eyre, a set of instructions issued to the justices who toured the country, conducting royal judicial business, with the specific mandate of keeping a record of crown pleas arising in each county. The word comes from the Latin corona, meaning crown, because the coroner was the crown's representative in matters of sudden or violent death. The coroner's primary function was not to determine cause of death in any medical sense. It was to protect the crown's financial interests by ensuring that the revenue-generating consequences of violent death were properly recorded and collected. This is, on reflection, a somewhat unglamorous origin for an office that modern societies vest with the solemn responsibility of investigating unexplained deaths. The medieval coroner was not primarily a seeker of truth or a protector of justice. He was an accountant, death's accountant, making sure that the king's financial interests in mortality were properly recorded and that the various fiscal consequences of sudden death flowed in the right direction. The coroner's inquest, the formal inquiry into a suspicious or sudden death, with a jury of local men, was the mechanism through which this fiscal accounting was performed. The inquest jury was not primarily there to determine what had happened in any broader sense of justice. They were there to determine whether the death gave rise to any financial obligation to the crown, and if so, what the nature and extent of that obligation was. The question of who killed whom, and what should happen to the killer, was the business of the royal courts. The question of what the king was owed as a consequence of the killing was the coroner's business. Nobody designed this system to last 800 years. It was designed to address the specific fiscal concerns of a medieval royal government that had developed an extensive and somewhat predatory interest in the financial consequences of violent death. As the specific medieval fiscal mechanisms, the deodand, the murdrum fine, the various crown pleas that generated revenue, were abolished over time, the fiscal rationale for the coroner's office disappeared entirely. The deodand was abolished in 1846. The murdrum fine had effectively disappeared centuries before that. By the mid-19th century, there was essentially no surviving medieval fiscal rationale for the coroner's existence, and yet the coroner survived. The office had, over 8 centuries, accumulated a different and more durable rationale: the genuine public interest in understanding the causes of unexpected and violent death, in maintaining a record of such deaths, in ensuring that deaths that might involve criminal liability were properly investigated, and in providing the formal legal determination of cause of death that modern administrative systems require. The fiscal accountant of the medieval crown had been transformed, gradually and without any single moment of deliberate redesign, into the death investigator of the modern state. The modern coroner, or the medical examiner who performs equivalent functions in jurisdictions that have replaced the coroner system with a more medically oriented alternative, conducts inquests into deaths that are unexpected, violent, or of uncertain cause, determines cause of death for legal and administrative purposes, and provides the formal mechanism through which the state takes account of deaths that are not straightforwardly explained. These are genuine and important functions. They bear essentially no relationship to the fiscal functions of the 1,194 coroner whose office they inhabit. The specific procedures of the coroner's inquest, the jury, the formal inquiry, the public nature of the proceedings, are medieval procedures, maintained in part because they serve genuine functions in the investigation of contested deaths, and in part because the legal framework that governs the coroner's office is so thoroughly built around them that replacing them would require legislative effort that has never quite risen to the top of anyone's priority list. The coroner's inquest jury is a direct descendant of the medieval inquest jury. 12 ordinary people hearing evidence, reaching a formal verdict on cause of death, operating within a legal framework whose basic structure was established in 1194 and has been modified but not replaced in the 8 centuries since. England and Wales have been debating the reform of the coroner system continuously and with limited decisive result for the better part of the last century. The fundamental structure, a local legally qualified officer conducting inquests with the assistance of juries, has proven extraordinarily resistant to comprehensive reform, partly because it serves important functions well enough to make replacement feel risky, and partly because the accumulated body of case law and procedural practice built up over 8 centuries is a genuine resource that reform would need to work around or replace. The deaths accountant of 1194 would not recognise the modern coroner's office. The office he occupied has been so thoroughly transformed by 8 centuries of accumulated function and accumulated purpose that the fiscal origins are invisible in the modern institution. But the office is there. The same office, the same word, the same basic structure of a local official conducting formal inquiries into unexpected deaths with the assistance of a jury, persisting from the fiscal arrangements of a medieval royal government into the administrative structures of a 21st century democracy because nobody decided to stop it. Chapter 9. The Calendar. Julius Caesar's scheduling error and its long consequences. You're trying to figure out what day it is. This sounds like it should be easy. It is not in the medieval world as straightforward as you might hope. The relationship between the civil calendar, the liturgical calendar, and the astronomical reality of the solar year is generating inconsistencies that are slowly accumulating into a problem that nobody has quite gotten around to solving, despite the fact that the mathematical nature of the problem has been understood for centuries. The Julian calendar, named for Julius Caesar, who reformed the Roman calendar in 46 BCE with the assistance of the Egyptian astronomer Sosigenes, established the year as having 365 days, with an extra day added every 4 years in a leap year arrangement. This was a significant improvement over the Roman calendar it replaced, which had become so badly misaligned with the actual solar year that the months no longer corresponded to the seasons they were supposed to represent. The Julian calendar was meant to fix this, to establish a stable, predictable calendar that would stay aligned with the astronomical year. It almost worked. The Julian calendar calculates the year as 365.25 days, the average length of the year when you include the leap year every 4 years. The actual solar year is approximately 365.2422 days. The difference is small, at about 11 minutes per year, but 11 minutes per year accumulates over centuries into a noticeable discrepancy. By the medieval period, the Julian calendar was running approximately 1 day ahead of the solar year every 128 years, and by the 16th century it had accumulated an error of about 10 days. Easter was drifting away from the spring equinox, which was theologically important because the Council of Nicaea in 325 had established that Easter should be calculated from the spring equinox. This was a known problem. The Venerable Bede had noted it in the 8th century. Roger Bacon had sent a memorandum to Pope Clement IV in 1267, pointing out the error and urging calendar reform. Various medieval scholars had identified the problem, quantified the error, and proposed solutions. The solutions required dropping a certain number of days from the calendar to realign it with the solar year and adjusting the leap year rule to prevent the error from accumulating again. The reform was not made, not in Bede's time, not in Bacon's time, not in the time of any of the various medieval scholars who identified the problem and proposed the solution. The calendar was a shared institution. It governed the entire liturgical life of the Western Church, which meant that reforming it required not just the will of the papacy, but the cooperation of the entire ecclesiastical structure of Western Christianity. The coordination problem was enormous, and the practical urgency of the error was, in any given year, small enough that it did not create the crisis that would have forced action. When the reform finally came, in 1582 under Pope Gregory XIII, with the adoption of what became known as the Gregorian calendar, it required dropping 10 days from the calendar in October of that year. October 4th, 1582 was followed by October 15th, 1582. 10 days simply disappeared. This was disorienting, and the practical consequences for contracts, legal obligations, and various other arrangements that were tied to specific dates required careful management. The Gregorian calendar was not immediately adopted everywhere. Catholic countries adopted it relatively quickly: Spain, Portugal, Italy, Poland, in 1582 or shortly after. Protestant countries were considerably more resistant, partly on theological grounds. Accepting a calendar reform initiated by the Pope felt, to many Protestants, like acknowledging papal authority that they had explicitly rejected. Britain and its colonies did not adopt the Gregorian calendar until 1752, by which point the error had grown to 11 days, and the September of 1752 required the deletion of 11 days. September 2nd was followed by September 14th, producing the popular legend, possibly apocryphal, of riots by people who felt their lives had been shortened by 11 days and wanted them back. Russia did not adopt the Gregorian calendar until 1918, after the Bolshevik Revolution, the Russian Orthodox Church having maintained the Julian calendar on theological grounds through the entire period of the Gregorian calendar's adoption in the rest of Europe. This is why the revolution that occurred in October 1917 by the Julian calendar that Russia was still using at the time is called the October Revolution, despite having occurred in what the rest of the world was calling November. The Julian calendar was a temporary fix for a real problem, a practical improvement over what it replaced, designed to solve the immediate issue of the Roman calendar's misalignment with the solar year. The fact that it was slightly imperfect, that 11 minutes per year would accumulate into a meaningful error over centuries, was not something that Caesar or Sosigens could have been expected to regard as urgently requiring immediate solution, because the consequences of 11 minutes per year take generations to become visible. The Gregorian calendar that replaced it is itself not perfect. It is slightly off from the solar year, though by a much smaller margin than the Julian calendar, and will eventually require its own correction in some thousands of years. The correction, when it comes, will face the same coordination problem that delayed the Gregorian reform for over 1,000 years after the error in the Julian calendar was first clearly identified. The calendar is a shared institution, and shared institutions resist reform with a stubbornness that is proportional to how completely everyone depends on them. Chapter 10. Parliamentary Procedure. How medieval arguments became modern rules. You're in Westminster Hall. The year is somewhere in the late 13th century, and the gathering that is taking place here, the representatives of the shires and boroughs, summoned by the king to advise and consent to taxation, meeting alongside the lords spiritual and temporal, who have always been part of the king's council, is becoming gradually and without fully intending to, a parliament. Not yet in the sense that the word will eventually acquire, but parliament in the etymological sense, from the old French parlement meaning a talking, a speaking, a discussion, because what is happening here is a great deal of organised talking, and some of it is beginning to develop regularised forms. The procedures that govern parliamentary debate in the legislatures of countries that inherited or modelled their systems on the Westminster tradition, Britain, Canada, Australia, New Zealand, India and many others, are medieval procedures, not in every detail. The specific rules have been added to, modified, interpreted and developed across 8 centuries of parliamentary practice. But in their fundamental structure, in the basic conventions that govern how a legislature conducts its business, the medieval origin is clearly visible. The concept of the Speaker, the presiding officer of the House of Commons, who chairs debates, calls members to speak and maintains order, dates to the medieval period. The first person clearly identified as Speaker of the Commons was Peter de la Mare, who fulfilled the role in 1377. The Speaker's role was originally exactly what the title suggests, the person who spoke on behalf of the Commons to the King, conveying the Commons' petitions and concerns to the monarch. The position evolved over centuries into something more complex, a neutral presiding officer with extensive powers over the conduct of debate, but the title reflects the medieval origin. The reading of bills, the convention that legislation is given multiple formal readings before it is enacted, with debate occurring between and around those readings, is a medieval procedure that originated in the practical necessity of reading proposed legislation aloud, in an era when most members of Parliament could not be assumed to have their own copies. The bill was read aloud so that all members could hear what was being proposed. 3 readings, introduction, debate, and final approval, became the standard because 3 was a number with sufficient formality and ritual weight to mark the seriousness of the legislative act. Bills are no longer read aloud to the full chamber in most legislatures. Printed copies are distributed to members who are expected to read them privately. The 3 readings nevertheless persist as a procedural framework whose original function has been entirely superseded by the technology of the printing press, but whose formal structure has been maintained as the organising framework for the legislative process. The first reading, the second reading, the third reading. These are stages in the legislative process of the British Parliament, the Canadian Parliament, the Australian Parliament, and numerous others, each stage representing a formal procedural moment whose content has been transformed beyond recognition, while its name and its position in the sequence remain as the medieval procedure established them. The concept of a quorum, the minimum number of members required to be present for legislative business to be conducted, is medieval in origin, reflecting the practical necessity of ensuring that decisions were made by a sufficient number of representatives to be legitimate. The specific quorum numbers in various legislatures reflect historical accidents of institutional development rather than any principled calculation of what number would be optimal, but the concept itself, that you need a certain minimum number of people present to conduct legitimate business, is a medieval institutional inheritance. The physical arrangement of the House of Commons, the 2 sides of benches facing each other across a central aisle, with the government party on one side and the opposition on the other, reflects the medieval origin of Parliament in the monastic choir stall arrangement of Westminster Abbey, where the Lords first met. The adversarial layout, designed for a monastic setting where the purpose was liturgical antiphony, rather than political debate, has been maintained in the British House of Commons, and has been reproduced in the legislatures of many countries that modelled their parliamentary architecture on Westminster, even when those countries were constructing entirely new buildings for the purpose. The most famous consequence of this physical arrangement is the convention that members of Parliament do not cross the floor of the House during debate, a convention that originated in the practical need to maintain the spatial distinction between the 2 sides, and that has evolved into a charged political metaphor. Crossing the floor, changing political allegiance, moving from one side to the other, is a phrase that has entered the political vocabulary of every Westminster tradition country as a description of a significant act of political apostasy, because the physical floor of the medieval chamber has become a metaphor for political loyalty that has outlasted the chamber whose layout generated it. Chapter 11. The Inns of Court. Legal education's medieval accident. You're in London in the late 13th century, and you're a young man who has decided that the law is where your future lies. The royal courts are producing a growing demand for trained lawyers, and the church, which previously provided much of the legal expertise that the courts required, is being pushed out of the common law courts by a professional bar of laymen who have developed their own expertise in the specific technicalities of English legal procedure. You need training, but there is no institution that provides it. No law school, no university law faculty that teaches English common law rather than Roman law. The universities teach Roman law and canon law, which are the legal systems of the church and the academic tradition. But English common law is something different, a system of practice developed in the royal courts, transmitted through the observation of court proceedings and the informal instruction of experienced practitioners. To learn it, you need to be where it is practiced, which is to say you need to be in London near the royal courts at Westminster. The solution that emerged, again, without any planning, without any institutional decision to create a new kind of educational institution, was the Inns of Court. The lawyers who practiced in the royal courts gathered in large houses or inns in the area between the City of London and Westminster that gave them convenient access to both. These inns provided accommodation, dining, and gradually an informal educational environment in which the younger members, students and junior practitioners, could learn the law by watching their seniors, by participating in the moot courts and other educational exercises that the inns developed, and by absorbing the culture and practice of legal advocacy through sustained immersion in the professional community. 4 inns, Lincoln's Inn, Gray's Inn, the Inner Temple and the Middle Temple, survived to become what they are today. The Inns of Court, the bodies through whose membership any person who wishes to practice as a barrister in England and Wales must qualify. The specific mechanism of qualification has changed enormously over 8 centuries. The modern path to the bar involves formal legal education, professional training, and examinations that bear no resemblance to the informal apprenticeship of the medieval inn. But the formal requirement that a barrister must be called to the bar by one of the 4 Inns of Court, must have dined there a specified number of times as part of the qualification process, maintains the medieval structure of the institution as an organising framework for the modern profession. The dining requirement is worth dwelling on for a moment, because it is one of the more charming survivals of medieval institutional logic into the present. The requirement that barrister students keep terms by dining in the inn a specified number of times reflects the medieval reality that the inn was a residential and dining community, and that participation in the communal life of the inn, including communal dining, was how learning happened. You learned the law by eating with lawyers, by hearing their conversations, by absorbing their culture and their professional values through sustained social contact. The educational function of communal dining has been entirely superseded. Modern barristers learn the law in universities and professional training courses that have no dining component. The dining requirement has been reduced from what it once was and has been modified to accommodate the realities of modern legal education. But it persists, because the inn is still a dining institution, because the call to the bar ceremony is still conducted within the inn's formal community, and because the medieval structure of the inn, as a communal organisation, has proven sufficiently durable that dismantling it has never seemed more worthwhile than maintaining it. Chapter 12. The Postal Service. Royal horses that became everyone's letters. You are riding hard. The year is 1516, and you are a royal courier in the service of Henry VIII, carrying dispatches along one of the routes that Thomas Randolph, the newly appointed Master of the Posts, has organised with a system of relay horses positioned at intervals along the main roads from London to the Scottish border. The horses are fresh at each stage. You transfer the dispatch to a new rider at each posting station, and the dispatch moves faster than any single horse and rider could carry it, because no horse is ridden to exhaustion and no rider is slowed by fatigue. The Royal Postal System, the organised network of relay horses and riders that allowed the Crown to communicate rapidly with its representatives across the country, was created as a private government service. It was not intended for public use. It was intended for royal dispatches, for government communications, for the movement of official correspondence at speeds that the ordinary traveller, limited by the capacity of a single horse and rider, could not match. The transformation of this private royal service into a public postal system happened gradually, driven by the discovery that private individuals were willing to pay for the privilege of using the relay system for their own correspondence, and that this willingness represented a revenue opportunity that the government could exploit without dismantling the system's primary function of serving royal communication needs. The extension of postal services to the public, which happened incrementally through the 16th and 17th centuries, formalised in England by the Act of 1660 that established the General Post Office, transformed a temporary royal convenience into a permanent public institution. The relay system, designed for royal dispatches, became the infrastructure for the movement of private correspondence across the country, then across the empire, then, through the International Postal Union established in 1874, across the world. The specific features of the postal system that reflect its medieval and early modern origins are visible in the terminology that postal systems still use. Post, from the Latin positum, placed, referring to the placed station relay horses, gives its name to the post office, the postman, the postal service. Mail, from the Old French mail, a bag or wallet, the container in which dispatches were carried, gives its name to email, airmail, and the general concept of correspondence as mail. The posting station, the place where relay horses were kept and dispatches transferred, gives its name to the modern post office, even though the modern post office has no horses and no relay system. The pillar box, the red cast-iron post box that is one of the most recognisable features of the British street landscape, was introduced in 1852 as a convenience for postal users who previously had to travel to a post office to deposit their correspondence. It was designed as a temporary experiment to see whether convenient collection points would increase the volume of mail. The experiment was successful. The pillar boxes were made permanent, and the specific design of the Victorian pillar box, modified slightly over the decades but fundamentally similar to the original, has become so thoroughly associated with British national identity that it was painted gold to honour Olympic gold medalists and has been the subject of more affectionate public attention than any piece of street furniture has any right to expect. Chapter 13. Weights and Measures. The medieval body as measurement system. You're buying cloth. The year is 1300, and the transaction you're engaged in involves a unit of measurement called a yard, which is, depending on who you ask and which specific local custom governs the market you're in, either the distance from the tip of the nose to the end of the outstretched arm, or the distance from the centre of the body to the end of the outstretched arm, or something else entirely that varies by region and by the specific trade custom that has developed in the specific market where you're shopping. Medieval measurement was magnificently inconsistent. The yard, the foot, the inch, the basic units of the English measurement system that eventually became the imperial system and that, in modified form, persists as the US customary system, were derived from human body proportions, and since human body proportions vary from person to person, the units derived from them varied from place to place and from context to context. A foot was, literally, the length of a foot. But whose foot? A yard was the distance from nose to fingertip. But whose nose? Whose fingertip? The effort to standardise these measurements, to fix them at a specific defined length that would be the same in every market and every transaction, began in the medieval period and has never quite finished. The Magna Carta of 1215 included provisions about standard measures of wine, ale, and cloth, reflecting the genuine commercial importance of measurement consistency and the equally genuine difficulty of achieving it. Edward I issued standard measures in 1305, attempting to fix the foot and the yard and various other units at defined values that would apply across the kingdom. The effort was partially successful and partially not, because measurement standards are only as good as the enforcement mechanisms that back them up, and medieval enforcement mechanisms had significant limitations. The specific origin story of the yard, the claim that it was defined by Henry I as the distance from the tip of his nose to the end of his thumb, is probably apocryphal, but it captures something true about how medieval measurement worked. Body-derived measurements were convenient because everyone had a body, and could use their own body as a rough standard in the absence of a measuring instrument. The inconvenience, that different bodies produce different measurements, was a problem that commerce required solving, and the solving of it produced the standardization efforts that eventually led to the fixed definitions of the imperial units. The foot, 12 inches, defined by the Romans and inherited by medieval Europe as a standard unit of length, has persisted in the United States as the primary unit of length in everyday use, despite the adoption of the metric system by essentially every other country on Earth. The metric system was designed in revolutionary France in the 1790s as a rational scientific alternative to the accumulated mess of body-derived medieval units, based on the metre, defined as 1/10,000,000th of the distance from the equator to the North Pole, subsequently redefined in terms of physical constants that provide a more stable and more universally accessible definition. Every country that was part of the British Empire or was significantly influenced by British commercial and administrative practice has gone through a metrication process, the formal conversion from imperial units to metric units, that was politically contested and practically difficult in ways that reflect how deeply the medieval measurement tradition was embedded in daily life, commercial practice, and cultural habit. Britain completed its official metrication in most contexts in the 1970s and 1980s, but retains imperial units in specific contexts, miles on road signs, pints in pubs, stones for human body weight, because the political resistance to changing these specific uses has consistently exceeded the political will to complete the conversion. The United States has not completed metrication at all, despite the Metric Conversion Act of 1975 and the establishment of the United States Metric Board to facilitate voluntary conversion. The medieval foot, the medieval inch, the medieval pound, these units derived from the body proportions and commercial practices of the medieval world persist in the everyday life of the world's largest economy, because the cost and disruption of changing them has consistently seemed greater than the cost and disruption of maintaining them. Chapter 14. The City of London. The medieval corporation that outlasted everything you were in the City of London. Not London, the city. The vast, sprawling metropolitan area of 9 million people that extends in every direction from the Thames. You're in the City of London, which is a different and considerably smaller thing, a square mile of territory at the centre of the metropolis, governed by a constitution of such medieval antiquity and such institutional peculiarity that explaining it to someone unfamiliar with it requires a degree of patience on both sides of the conversation. The City of London Corporation, the local government authority that governs the square mile, is the oldest continuously functioning local government body in the world. Its origins are in the charters and privileges that medieval kings granted to the merchants and citizens of London in exchange for the financial support that those merchants and citizens were in a position to provide. The city's constitution has been modified many times over its 1,000-year history, but it has never been replaced, never subjected to the comprehensive reform that has restructured local government in the rest of England multiple times since the 19th century. It persists, in its medieval essentials, as a living institutional fossil of extraordinary historical interest and, to the people who understand how it works, of considerable practical significance. The aldermen of the City of London, the senior elected officials of the corporation, hold an office that dates to the Anglo-Saxon period. The word itself is Old English. Elderman, literally elderman, a word that is older than the Norman conquest, and that has survived the Norman conquest, the Black Death, the Reformation, the Civil War, the Industrial Revolution, the 2 World Wars, and everything else that has happened to Britain in the intervening millennium, still being used to describe the senior elected officials of the corporation in the 21st century. The Lord Mayor of London, not to be confused with the Mayor of London, who is the elected mayor of the broader metropolitan area and who is a creation of the late 20th century, is elected annually by the livery companies and the aldermen of the city in a ceremony that has been conducted in essentially the same form since the medieval period. The Lord Mayor serves a 1-year term, lives in the mansion house during that term, and exercises a range of ceremonial and representative functions on behalf of the city that reflect the medieval understanding of the Lord Mayor as the representative of the city's collective commercial and civic interest to the Crown and to the world. The livery companies, the ancient guilds of the City of London, each associated with a specific trade or craft, each with its own hall, its own livery, its own charitable functions, and its own history stretching back to the medieval period, are the bodies whose members elect the Lord Mayor and the aldermen. The livery companies range from the ancient and the practically significant, the mercers, the grocers, the haberdashers, the fishmongers, all of whose trades were of enormous commercial importance in medieval London, to the recently created and somewhat whimsical, the Worshipful Company of Information Technologists, incorporated in 1987, and the Worshipful Company of Management Consultants, incorporated in 2004, both of which have adopted the medieval guild form as a framework for professional networking and charitable activity in trades that did not exist when the guild system was developed. The fact that the medieval guild form is still being used to create new professional organisations in the 21st century is, in its own small way, one of the more remarkable pieces of evidence for the institutional durability of medieval forms. The Worshipful Company of Information Technologists is not a medieval institution. It was created 37 years ago, and its members are engaged in a profession that would be incomprehensible to any medieval guildmaster. But it chose the medieval form, the livery, the hall, the master and wardens and court of assistants, the charitable purposes, the place in the hierarchy of the city's ancient constitution, because the form was available, because it was recognised and legitimated by the existing institutional framework, and because the prestige of the ancient guild tradition was worth something to the professional community that adopted it. The City of London's ancient constitution has survived comprehensive local government reform in England in 1835, in 1888, in 1963, and in the various subsequent reorganisations of London government, precisely because the city's political influence, the financial and commercial interest concentrated in the square mile, and their ability to make the case for the preservation of the city's constitutional distinctiveness, has consistently been sufficient to exempt it from the reforms applied to every other part of the country. The medieval corporation has survived not by accident, but by the active exercise of institutional self-preservation, using the political and financial influence of the interests it represents to fend off the standardising ambitions of successive reforming governments. This is, in a sense, the most honest explanation for why a great many medieval things survive into the present. They do not survive because they are better than the alternatives. They do not survive because no one has noticed that they are medieval. They survive because the interests that benefit from their survival are powerful enough and well organised enough to resist the periodic efforts to replace them, and because the costs of reform, in political capital, in disruption, in the practical difficulties of replacing something that is embedded in the legal and administrative fabric of daily life, consistently exceed the benefits that reformers can demonstrate. The City of London is the clearest example of this dynamic, because the self-preservation instinct of its constitution is so explicit and so well organised. But the same dynamic operates, less visibly, in the persistence of every other medieval institution we have discussed. The medieval university, the jury system, the common law, the parish, the coroner. All of these have survived in part because the interests that benefit from them, or the communities that find meaning and identity in them, have consistently been more motivated to preserve them than reformers have been motivated to replace them. Chapter 15. Sanctuary. The Church. Protection that became modern asylum. You are in a church, not attending a service, not at this moment engaged in any act of worship or religious observance. You are here because you need to be here, because the specific legal privileges that attach to this building under the law of sanctuary are the only thing standing between you and a very unpleasant interaction with the law. You have touched the sanctuary knocker on the door, that great iron ring, in a church that has one, and by doing so, you have claimed the protection of the church. For the next 37 days, under the terms that sanctuary law provides, you cannot be removed from this church by force. You are, for a specific and limited period, under the protection of God and the church, and that protection is recognised by the secular law. Sanctuary, the principle that certain sacred places, primarily churches, provided temporary legal protection to persons fleeing from secular authority, was one of the most important and most complex intersections between ecclesiastical and secular law in the medieval period. Its origins were ancient, predating Christianity in some forms, but in Western Europe it developed as a specifically Christian institution through the interaction between church authority and secular law over several centuries. The logic of medieval sanctuary was theological and practical simultaneously. Theologically, the church was a sacred space, whose violation by secular violence would be a desecration, an affront to God that the church could and did punish through its own legal mechanisms, including excommunication. Practically, the recognition of sanctuary served the secular law's interest in preventing blood feuds and providing a mechanism through which accused persons could reach a formal legal process rather than being killed by their accusers before they ever reached a court. The medieval sanctuary system in England was elaborate and carefully defined. Parish churches provided sanctuary for 40 days, enough time for the accused person to confess to the coroner, abjure the realm, formally renounce their right to remain in England and agree to go into permanent exile, and depart the country under escort. Certain privileged sanctuaries, Westminster Abbey, the Sanctuary of St Martin le Grand in London, Beverley Minster, and a handful of others, provided permanent or extended sanctuary, allowing persons who reached them to remain for extended periods or indefinitely, in a legal limbo between the secular and the ecclesiastical worlds. The sanctuary was not impenetrable. There were crimes for which sanctuary could not be claimed, treason against the crown being the most significant, reflecting the principle that sanctuary was a protection against the ordinary operation of the law, but not against the king's direct authority in matters of national security. And the 40-day clock was a genuine constraint. If you had not abjured the realm, within 40 days you could be starved out since no food could be brought to you from outside the sanctuary. The abolition of sanctuary in England happened gradually, through a series of legislative acts in the 16th and 17th centuries, as the Reformation reduced the Church's institutional authority over secular matters, and as the Crown's interest in maintaining effective criminal jurisdiction across the entire territory became dominant over the competing ecclesiastical interest in maintaining the Church's protective functions. The Sanctuary Act of 1623 formally abolished most remaining sanctuary rights for criminal cases. But the idea of sanctuary, the principle that certain places and certain institutions can and should provide protection to persons fleeing persecution or legal jeopardy, did not disappear with the legal institution. It evolved, transformed, and reappeared in new forms that maintain the fundamental logic of the medieval institution while operating in entirely different legal and institutional contexts. The right of diplomatic asylum, the protection offered to persons who take refuge in a foreign embassy, is the direct institutional descendant of medieval sanctuary, translated from the sacred space of the Church to the protected space of the diplomatic mission. The legal principles governing diplomatic asylum, that the host country's law enforcement cannot enter the premises without the permission of the diplomatic mission, that the mission can offer protection to persons who have reached it, are recognisably similar in structure to the principles of medieval sanctuary, even though they operate in the completely different legal framework of international diplomatic law. The right of asylum in international refugee law, the principle, established in the 1951 Refugee Convention and its 1967 Protocol, that persons fleeing persecution have the right to seek protection in another country and cannot be returned to the country where they face persecution, is the broadest modern expression of the sanctuary principle, extended from the specific space of the Church or the diplomatic mission to the territory of the asylum-granting country itself. The principle that a person facing persecution has a right to protection that overrides the ordinary operation of border control and immigration law is, in its deepest moral logic, the same principle that the medieval Church expressed through the institution of sanctuary. The word itself persists in contexts that maintain the medieval association between sanctuary and protection. Churches that declare themselves sanctuary churches, providing protection and support to undocumented immigrants or other persons at risk of detention, are explicitly invoking the medieval tradition, using the word and the institutional association to claim for their protective activities a moral legitimacy rooted in the deep history of the practice. The cities and jurisdictions that declare themselves sanctuary cities, committing not to cooperate with federal immigration enforcement in certain ways, are using the medieval vocabulary of sacred protection in a contemporary political context, because the word carries exactly the moral weight that they want to claim for their policies. Chapter 16. The Tournament. Organised violence that became modern sport. You're watching a tournament. The year is 1250, and the field before you is not the elegant, controlled, ceremonially organised event that later ages will associate with the word tournament. The carefully managed jousts of the later medieval period, conducted within fixed boundaries with trained judges and elaborate rules about permissible weapons and conduct. What you are watching is closer to a battle, a melee, a mass-mounted combat in which two teams of knights fight each other across a large area of open country, taking prisoners who must pay ransoms and doing genuine damage to each other with genuine weapons. The tournament was, in its early medieval form, a training exercise for war, a way for knights to practice the skills of mounted combat in conditions that were nearly real, against opponents who were genuinely trying to defeat them, with consequences, injury, death, financial ruin through ransom, that were real enough to create the pressure that genuine training requires. It was not a spectator entertainment, not a ceremonial display, not a festival of chivalric romance. It was organised violence with a practical military purpose. The church hated it. Popes issued prohibitions against tournaments with a frequency that reflects how consistently the prohibitions failed to stop them. The prohibition of tournaments by various councils and papal decrees throughout the 12th and 13th centuries produced the specific medieval situation where something that everyone was doing was simultaneously illegal under canon law, often prohibited under secular law, and so thoroughly embedded in the aristocratic culture of the period that stopping it would have required a level of enforcement commitment that no authority was willing to maintain. The tournament survived, transformed itself, and in transforming itself produced a range of modern sporting and competitive practices that bear the marks of their medieval origin in various ways. The joust, the individual mounted combat between two knights that developed as a more controlled alternative to the chaotic melee, is the direct ancestor of the equestrian sports of the modern period. Show jumping, dressage, eventing, the Olympic equestrian disciplines, are the descendants of the specific horsemanship skills that the tournament developed and rewarded. The concept of the tournament itself, a competition organised to determine the best practitioner of a specific skill with multiple competitors, structured rounds, and an ultimate winner, is the organising principle of essentially every modern competitive sport. The word tournament is still used in tennis, in chess, in golf, in football, in video gaming, in any context where multiple competitors are organised into a structured competition to determine an overall winner. The word carries its medieval origin lightly. Most people using it are not thinking about 12th century knights galloping at each other, but the organisational concept is the same. The heraldry that developed in connection with the tournament, the system of coats of arms, standardised designs on shields and surcoats that allowed combatants in a melee to identify friend from foe, has had an afterlife that extends far beyond its military or aristocratic origins. Heraldic designs appear on national flags, on sports team logos, on university crests, on commercial brands, on the emblems of organisations that have no aristocratic connection but have found in the visual vocabulary of heraldry a design language of appropriate seriousness and historical weight. The specific conventions of heraldry, the tinctures, the charges, the rules about colour on colour and metal on metal, are medieval conventions that the design world has absorbed and continues to draw on. Chapter 17. The Charter. The temporary grant that became constitutional bedrock. You are at Runnymede. The year is 1215, and the scene taking place in the meadow beside the Thames, King John of England setting his seal to a document that a group of rebellious barons have forced on him after a period of military and political confrontation, is not, at this moment, understood by anyone present as a foundational moment in the history of constitutional government. It is understood as a practical political settlement, a list of specific grievances and specific remedies, hammered out between a king who has run out of options and barons who want their specific complaints addressed and are prepared to force the issue. The Magna Carta, the Great Charter, was not intended to be a constitutional document in any grand sense. It was intended to be a peace agreement. It addressed specific feudal grievances about the specific abusive practices of John's specific reign. It said that the king could not take scutage, a feudal payment in lieu of military service, without the consent of the council. It said that free men could not be imprisoned except by the judgment of their peers or the law of the land. It said that justice could not be sold, delayed, or denied. These were practical remedies to practical abuses, not philosophical statements about the nature of government and human rights. John had no intention of honouring it. He appealed to Pope Innocent III, who annulled it within months. John was dead within a year, and the Magna Carta survived as a practical political document primarily because the regents governing on behalf of his young son, Henry III, found it useful to reissue it as a gesture of goodwill toward the barons whose support they needed. The transformation of this practical political settlement, this temporary peace agreement between a specific king and specific barons about specific grievances, into the foundational document of Anglo-American constitutional tradition happened over centuries, through a process of legal and political interpretation that discovered in its general principles things that the specific text, read in its original context, does not clearly say. Clause 39, the provision about judgment by peers and the law of the land, became, through centuries of lawyerly interpretation, the foundation of habeas corpus, of due process, of the principle that the state cannot deprive a person of liberty without following legal procedures that are themselves constrained by law. These interpretations went well beyond what King John's barons were arguing about in 1215. But they were not simply invented. They were drawn out of language that was genuinely open to these readings, developed by lawyers and judges who found in the Magna Carta the authority for principles they were committed to for reasons that went beyond the specific 13th century context. The Magna Carta was reissued multiple times in the 13th century, by Henry III and later by Edward I, in modified forms that reflected the changing political circumstances of each reissue. Each reissue reinforced its status as a fundamental statement of English law. By the time Edward Coke invoked it in the 17th century as the foundation of parliamentary authority against the claims of the Stuart kings, the Magna Carta had been transformed from a baronial peace agreement into the constitutional bedrock of English liberty, a transformation that required 8 centuries of interpretation and institutional development to complete. The Magna Carta is now displayed in national archives and museum exhibitions as one of the most important documents in the history of constitutional government. It has influenced the constitutions of numerous countries, including the United States Constitution and the Universal Declaration of Human Rights. The specific clause about judgment by peers has echoed through centuries of legal development into the modern right to a fair trial. The specific clause about selling or delaying justice has echoed into the modern due process tradition. None of this was intended by King John or his barons. The document was meant to end a specific rebellion, address specific grievances, and allow a specific political situation to be resolved. The permanence that it acquired was not its own intention, but the consequence of what later generations found in it and chose to make of it, the discovery, in a temporary peace agreement, of principles that turned out to be permanent. Chapter 18. The Bells. Medieval timekeeping that never stopped ringing. You are listening. It is early in the morning, the sun is not yet fully up, and the village around you is beginning its daily transition from sleep to wakefulness in the gradual, organic way that pre-industrial communities woke, not to an alarm but to the accumulated cues of light and sound that mark the transition between night and day. And the most organised of those sound cues, the one that coordinates the community's collective movement from rest to activity in a way that individual perception of light cannot, is the bell. Church bells in medieval Europe were the primary technology for coordinating communal time. In a world without clocks, mechanical clocks do not appear until the late 13th century, and personal timepieces are centuries further away. The bell is how you know when things happen. The canonical hours, the divisions of the day that monastic life organised itself around, were marked by bells that the surrounding community, even its non-monastic members, used as their temporal reference points. Prime, terce, sext, none, vespers, compline. The bell told you where you were in the day, when to begin work and when to stop, when the market opened and when it closed, when the court was in session and when it had concluded. The word noon, the midpoint of the day, 12 o'clock, derives from the canonical hour of none, which was originally the 9th hour of the day after sunrise, approximately 3 in the afternoon. Over time, the hour of none moved earlier, in the monastic schedule, the meal that followed it being a sufficiently attractive incentive to bring the hour forward, until it arrived at the middle of the day, around 12, where it has remained ever since. Every time someone says noon, they are using a word that records the medieval monastic schedule's gradual adjustment of mealtimes, preserved in the language as a fossil of the temporal system that the bells enforced. The specific rhythm of bells, the patterns of ringing that encode different messages, tell the community different things about what is happening, is a medieval communication technology that persists, in attenuated form, in the bell-ringing traditions of churches that still use bells for the purposes they were designed for. The passing bell, rung when a member of the community was dying to call for prayers, has given its name to the death knell, a phrase that persists in the language as a metaphor for the end of something. The curfew bell, the evening bell that signalled the time after which fires were to be covered, from the old French couvre-feu, cover fire, has given its name to the modern legal restriction on movement after a certain hour, preserving in a legal term the medieval fire management practice that the bell originally announced. The hourly chime of clock towers, the mechanical clock's replacement for the bell's time-marking function, is the direct successor of the medieval bell's role in marking the hours. Big Ben, the clock tower at the Palace of Westminster, is not a bell tower in the medieval sense. It is a mechanical clock with a bell strike mechanism. But its social function, marking the hours for the surrounding community, providing a shared temporal reference point, being the audible infrastructure of coordinated social life, is the same social function that the church bell performed in the medieval village. The technology has changed. The function and the relationship between the sound and the community is medieval. Chapter 19. The Inn. Hospitality as infrastructure that built the modern hotel. You're tired. You have been travelling for 2 days on roads that have tested your horse's patience and your own, and the light is fading in the way that makes the prospect of a fire and a meal and a bed feel like something approaching paradise. Ahead of you, the sign of an inn, a painted board, or a bundle of greenery hung above the door, promises that these things are available in exchange for money, and you direct your horse toward it, with the specific relief of a traveller who has found what they were looking for before the dark became complete. The medieval inn was a necessity, not a luxury. In a world where travel was slow, distances were real, and spending the night outdoors was not merely uncomfortable but genuinely dangerous, the inn was the infrastructure that made extended travel possible. It provided shelter, food, drink, and stabling for horses, the complete package of requirements for a traveller, in an era when everything you needed for a night's rest had to be supplied by a commercial establishment, because carrying it with you was impractical. The specific form of the medieval inn, a courtyard surrounded by rooms and stabling, with a common room for dining and a range of private rooms for sleeping, organised around the service of food and drink and the accommodation of travellers and their horses, established a template for commercial hospitality that has proven extraordinarily persistent. The modern hotel is, in its fundamental structure, the medieval inn adapted for the transportation and comfort standards of successive centuries. The courtyard replaced by a lobby, the stabling replaced by a car park, the common room replaced by a restaurant and bar, the private rooms upgraded but serving the same basic function they served in 1300. The word inn persists in commercial hospitality, naming in ways that maintain the medieval association. Holiday Inn, Inn at the Park, the countless pubs and hotels that include inn in their name as a signal of welcome, warmth, and the provision of the specific set of services that travellers have needed since the medieval period. The pub, the public house, the successor of the medieval tavern and the alehouse, is the institution that has most directly preserved the social function of the medieval inn, providing food and drink and a gathering place for the local community in a form that has been continuous since the medieval period, despite enormous changes in what is eaten, what is drunk, and who is welcome. The specific legal framework governing licensed premises, the requirement that establishments serving alcohol hold a license, that the license be issued by a public authority and subject to conditions about hours, conduct, and the protection of public order, is descended from the medieval regulatory framework that tried to manage the social and public order consequences of establishments that served alcohol to large numbers of people. The licensing of alehouses was a medieval administrative concern. The licensing of pubs and bars and restaurants is a contemporary administrative concern. The specific legal mechanisms are different. The fundamental problem, how do you allow commercial hospitality while managing its consequences for public order and social welfare, is the same problem that medieval administrators were trying to solve. Chapter 20. The Forest Law. When the King's Deer became your national park, you are in a forest, not a forest in the modern sense, not a managed woodland of neat rows of commercially planted conifers, not a nature reserve with designated walking paths and information boards explaining which species of beetle you might expect to encounter if you look carefully under the right log. You are in a forest in the medieval sense, which is a considerably more specific and considerably more legally charged thing than simply a large area of trees. You are in a royal forest, and the fact that you are in it without the appropriate permission, carrying the inappropriate equipment at the inappropriate time of year, means that you are, by the laws of England as they currently stand in the 12th century, in very serious trouble indeed. The royal forests of medieval England were not primarily forests in the ecological sense, though they frequently contained trees. They were legal designations, areas of land placed under a specific body of law, the forest law, which superseded the ordinary common law within their boundaries and which existed for one primary purpose: the protection of the king's deer and the king's hunting. A royal forest could include farmland, villages, moorland and heathland as well as woodland. What defined it as a forest was not its vegetation but its legal status, and that legal status was enforced by a dedicated bureaucracy of forest officials: the verderers, the foresters, the regarders, the adjusters, whose existence and whose salaries depended on the vigorous prosecution of forest offences. The forest offences were elaborate and the penalties ferocious. Taking the king's deer, venison in the forest law's terminology, from the Latin for hunted animal, rather than specifically the flesh of a deer, was a capital offence in the Norman period, subsequently reduced to blinding and castration, and later further reduced to fines and imprisonment. Taking wood, the offences of waste, assa and perpresture, which covered respectively the destruction of trees, the clearing of forest land for agriculture, and the enclosure of forest land, were serious offences prosecuted in the specialised forest courts. Even keeping a dog in the forest required that the dog be lawed, have the 3 central toes of one front foot removed to prevent it from chasing deer, a procedure whose name has given us the modern word to lame. The royal forests at their 12th century peak covered roughly a third of England, an extraordinary proportion of the country placed under a legal regime that existed primarily to serve the king's pleasure in hunting. The political consequences of this were significant enough that the Forest Charter of 1217, the less famous sibling of the Magna Carta, issued in the same reform movement, addressing specifically the abuses of the forest system, is sometimes considered equally important in the history of English constitutional development, even though it has never achieved the Magna Carta's cultural prominence. The Forest Charter reduced the extent of the royal forests, limited the powers of forest officials, and established certain rights of common people within the forests that the forest law had previously suppressed. It did not abolish the forest law or the royal forests. It reformed them, moderated them, made them somewhat less oppressive. The forests remained legally distinct areas, governed by their own courts and their own officials, for centuries after the Charter. What happened to the royal forests over the subsequent centuries is a story of gradual transformation, of legal status changing, of the specific medieval institutions of the forest bureaucracy atrophying, of the forests themselves being used for different purposes as the specific importance of royal hunting diminished and the specific importance of timber for naval construction grew. The New Forest, William the Conqueror's creation, one of the original royal forests still existing in Hampshire as one of the largest remaining areas of ancient woodland in England, is the clearest surviving example of what the medieval forest system created. The New Forest's survival is partly a consequence of the specific legal and institutional legacy of the medieval forest law. The Court of Verderers, the medieval forest court staffed by the verderers whose title comes from the Old French for green, still meets in the New Forest today, not as a relic, not as a historical reenactment, as a functioning court, exercising real jurisdiction over the management of the forest under legislation that maintains the basic institutional structure of the medieval forest governance even as it has modernised its specific provisions. The New Forest National Park, created in 2005, overlaps almost exactly with the boundaries of the medieval royal forest, the boundaries that were established by Norman kings to protect their hunting, enforced by a medieval bureaucracy for centuries, and preserved through the accumulated legal history of the area into a modern conservation designation. The National Park Authority and the Court of Verderers coexist in the same territory, managing the same landscape, one as an ancient medieval institution and one as a modern conservation body, both serving the same fundamental purpose of protecting a specific area of land from the kind of development and exploitation that would destroy what makes it valuable. The principle that underlies both, that certain areas of land should be protected from ordinary commercial exploitation and maintained in a condition that serves some public or royal interest, is the forest law principle, translated from the protection of the king's hunting into the protection of biodiversity and public access and landscape character. The specific content of what is being protected has changed entirely. The basic legal and institutional logic has not. The national park system that exists in Britain, the United States, and many other countries is not, of course, a direct descendant of the medieval royal forest in any simple institutional sense. Yellowstone, designated in 1872 as the first modern national park, was not modelled on the New Forest. But the legal concept that the state can designate specific areas of land as subject to special protective regulations that override the normal rights of ownership and use is a concept whose history in English law runs directly through the medieval forest law. The idea that there is a category of land that is not subject to the ordinary rules of private property and commercial development, that some land belongs in some sense to everyone and therefore to no one, is an idea that the medieval forest system expressed in its own way, for its own purposes, and that modern conservation law expresses in its own way, for its own purposes. The deer are still there in the New Forest. They are no longer the king's deer in any legally meaningful sense. But the court of verderers still meets, the ancient forest still stands, and the legal designation that protects it carries, in its institutional DNA, the Norman king who created the forest law to protect his hunting 8 centuries and a completely transformed set of purposes ago. Chapter 21. Academic Latin, the dead language that refuses to die in universities. You are at a graduation ceremony. The hall is full, the gowns are on, the mortarboards are being adjusted with the self-conscious awkwardness that mortarboards always seem to generate in people who do not normally wear them. The official conducting the ceremony is speaking, and what they are saying is partly in English and partly in something else, something that is Latin, or at least Latin-shaped, delivered with the specific, confident incomprehensibility of a phrase that has been used so many times in this specific context that everyone present understands what it means, without necessarily understanding what it says. Admitto te ad gradum. You are admitted to the degree. The specific Latin formula that admits candidates to their degrees at graduation ceremonies is, in many universities, the actual moment of conferral. The legally operative phrase, the speech act that creates the graduate's entitlement to the credential. It is said in Latin because it has always been said in Latin, because Latin was the language of the medieval university, in which the formula was first developed, because changing it would require a collective institutional decision that nobody has made, and because there is something satisfying about the continuity, about the connection between the modern graduate in their borrowed gown and the medieval scholar who received their degree in the same language, in a ceremony whose basic structure has been maintained across 7 or 8 centuries of educational development. Latin was the language of the medieval university for reasons that were, in their original context, entirely practical. The universities of medieval Europe drew students from across the continent, from England and France and Germany and Italy and Spain and Bohemia, all speaking different vernacular languages and none of them speaking any of the others. The language that connected them was Latin, not the classical Latin of Cicero and Virgil, which had not been a living spoken language for centuries, but the medieval Latin that the Church had maintained as the language of liturgy, scholarship and official communication across the whole of Western Christendom. A university in Paris could teach students from Bologna and Oxford and Prague, because they all read and wrote Latin. The lecture was given in Latin. The disputations were conducted in Latin. The degrees were conferred in Latin. The texts were written in Latin. As vernacular languages developed in prestige and in their capacity to handle complex intellectual material, as scholars began to write philosophy and science and history in Italian, in French, in English, in German, the practical necessity of Latin as the universal medium of scholarly communication gradually diminished. The printing press accelerated this process by making texts available in vernacular languages to readers who did not know Latin. The Reformation reinforced it by making the vernacular languages of religion, Luther's German, Tyndale's English, legitimate vehicles for the most serious spiritual content. By the 17th century, major scholarly works were being published in the vernacular languages of their authors, and Latin was no longer the only possible medium for serious intellectual work. But Latin did not disappear from the university. It retreated from the lecture hall, from the dissertation, from the daily medium of scholarly communication, but it retreated slowly and incompletely, leaving deposits at various points in the institutional structure of the university that have proven extraordinarily resistant to removal. The graduation ceremony is the most publicly visible of these deposits. The Latin formulas of conferral, the Latin titles of the degrees, baccalaureus, magister, doctor, the Latin mottos of universities, the Latin inscriptions on diplomas, all of these maintain Latin as a ceremonial presence in the institution that was built around it, long after it ceased to be a functional one. The specific degree titles that universities use are Latin that has been adopted into English with varying degrees of adaptation. Bachelor, from the medieval Latin baccalaureus, whose own etymology is disputed, was the title of the junior member of the academic guild, the person who had completed the first level of training and was licensed to teach at a basic level while continuing their own studies. Master, from the Latin magister, teacher, was the full qualified practitioner, the person with the authority to teach independently. Doctor, from the Latin doctor, teacher, from docere, to teach, was originally synonymous with master, both titles indicating a person of full academic qualification. The differentiation between the master's and doctoral degrees developed gradually and is not fully standardized even today across different countries and disciplines. The word university itself is Latin, universitas, a corporation or guild as we established in the first chapter of this video. The word college is Latin, collegium, a group of colleagues, people bound together by a shared purpose. The word campus is Latin, the field or ground on which the institution stands. Alumni and alumni, the graduates of an institution, are Latin. Curriculum, the course of study, is Latin. Syllabus, the outline of a course, is Latin, or rather a Latinized Greek, and its current meaning is the result of a 17th century misreading of a manuscript that propagated itself through the scholarly literature before anyone caught the error, which is the kind of thing that happens when you're using a dead language as a live medium of communication. The Latin that appears in the institutional vocabulary of the modern university is not, for the most part, functioning as a language in any communicative sense. It is functioning as a marker of institutional continuity, a signal that this institution, whatever else has changed about it, maintains a connection to the tradition of learning that the medieval university established and that Latin embodied. The Latin on the diploma is not there to be read by anyone who knows Latin. It is there to look like it comes from somewhere important and old, which it does, and to signal that the credential it confers carries the weight of that importance, and that age, which it does, and to connect the person receiving it to a tradition of intellectual achievement that predates the specific institution conferring the degree by several centuries. This is not cynical. It is, in its own way, honest about what institutional tradition actually does, about the specific kind of legitimacy that comes from continuity, from being part of something that has been going on long enough that it has accumulated a weight of history that no single institution or individual could generate from scratch. The Latin on the diploma is the diploma saying, "This matters, it has always mattered. People have been doing this since before you were born, and before your parents were born, and before your country was born, and you are now part of that." The PhD, the Doctor of Philosophy, is the highest academic degree in most disciplines, and its name reflects a medieval understanding of philosophy as the queen of the sciences, the discipline that encompassed all systematic knowledge. A PhD in biochemistry is, technically and etymologically, a doctorate in philosophy, a title that reflects the medieval curriculum's organisation of knowledge into philosophy and theology, and law and medicine, in which philosophy covered everything that theology, law and medicine did not. The biochemist receiving a Doctor of Philosophy is connected through the Latin of the title to the medieval scholar receiving their degree in a cold stone hall with no biochemistry in sight, in a ceremony conducted entirely in a language that neither of them speaks as their mother tongue. The connection is real, and the Latin, incomprehensible, ceremonial, stubbornly persistent, is the thread that maintains it. Chapter 22. The Sheriff, the King's man who became America's lawman. You're in a shire. The year is approximately 1000, and the administrative unit you're in, the Shire, is one of the building blocks of the Anglo-Saxon Kingdom of England, a regional division that the West Saxon kings have been using to organise the governance of their expanding territory since at least the 9th century. The Shire has its own court, the Shire Court, which meets twice a year and handles the significant legal business of the region. And presiding over the Shire, as the king's representative in this regional administrative unit, is an official whose title is the Shire Reeve. The Reeve, the steward, the administrative manager of the Shire, acting on behalf of the Crown. The Shire Reeve. Say it quickly, say it again, notice what it becomes. Sheriff. The Sheriff, one of the most recognisable figures in American popular culture, the star of countless westerns, the elected law enforcement officer of the American county, the man in the hat with the badge, is, etymologically and institutionally, the Anglo-Saxon shire reeve, the king's administrative manager of a regional unit of English governance, carried across 11 centuries of institutional history and 3,000 miles of ocean to become the elected county official of the American frontier. The journey from Anglo-Saxon shire reeve to American county sheriff is not a simple straight line, but it is a continuous one. The Norman conquest of 1066 preserved the office of sheriff. The Normans found it useful, adapted it to their own administrative purposes, and maintained it as the primary instrument of royal authority at the county level. The medieval sheriff was a powerful figure, responsible for collecting the royal revenues from the county, for executing royal writs and legal judgments, for maintaining order, for producing prisoners for royal courts, and for a range of other functions that made the office the most significant local expression of royal government in the medieval administrative system. The sheriff's power was also, inevitably, a source of abuse. The Sheriff of Nottingham, the villain of the Robin Hood stories, whose legend crystallised around the specific social tensions of the 12th and 13th centuries, is a figure whose legendary wickedness reflects the genuine potential for abuse that the medieval sheriff's extensive powers created. The sheriff controlled the county's fiscal relationship with the crown, which meant the sheriff controlled how much ordinary people paid and how much was quietly diverted. The sheriff controlled the execution of legal process, which meant the sheriff controlled who was arrested and who was not, which judgments were enforced and which were left to wither. The sheriff was the crown's man, and the crown was a long way away, and the opportunities for self-enrichment in the gap between royal instruction and local execution were considerable. The Magna Carta addressed the abuses of the sheriff specifically, including provisions about the conduct of sheriffs and the limitation of their powers. Reflecting the genuine political importance of the sheriff's office in the constitutional conflicts of the early 13th century. The gradual limitation of the sheriff's powers through the medieval and early modern period, the transfer of judicial functions to the justices of the peace, the transfer of fiscal functions to other officials, the reduction of the sheriff to a primarily ceremonial and administrative officer, reflects the political history of the struggle to constrain the office's potential for abuse. By the time England was colonising the eastern seaboard of North America in the 17th century, the sheriff was a familiar figure in English local government, the county's senior royal official, responsible for executing court orders and maintaining a general responsibility for law enforcement at the county level. The colonial governments of Virginia and the other early colonies adopted the sheriff as their county law enforcement officer, because the sheriff was the model they knew, the English model of county-level governance that they were transposing to the American context. The crucial transformation that turned the English appointed sheriff into the American elected sheriff happened through the specific political culture of American democracy, where the English sheriff was appointed by the Crown or later by the Lord Chancellor. The American sheriff was elected directly by the voters of the county in a democratic expression of local self-government that the American political tradition valued enormously. The elected sheriff was accountable to the community in a direct and immediate way that the appointed English sheriff was not, and this accountability was understood as the democratic solution to the specific problem of abuse that the appointed sheriff's extensive powers had created in the medieval and early modern English context. The American county sheriff of the 21st century is an elected official in 46 of the 50 states. The sheriff is directly elected by the county's voters, with responsibility for law enforcement in the unincorporated areas of the county, for operating the county jail, for executing court orders, and for a range of other functions that vary by state, but that collectively reflect the accumulated institutional history of the office, from its Anglo-Saxon origins through its medieval development and its American transformation. The badge that the sheriff wears, the 5-pointed or 6-pointed star that is one of the most recognizable symbols in American iconography, is itself a medieval inheritance, though the specific connection is somewhat indirect. The star badge developed in American law enforcement in the 19th century, drawing on the heraldic tradition of the star as a symbol of authority, which is a medieval tradition. The specific form of the sheriff's star, punched from a coin or cast in silver, with points that vary by department and by tradition, is American. But the use of a heraldic symbol of authority as the physical marker of an official's office is the medieval practice of wearing one's authority on one's body, translated from the livery and the coat of arms to the badge. The word itself is perhaps the most direct and most remarkable thread. Every time an American says sheriff, every time the dispatcher calls for the sheriff's department, every time a Western movie credits the sheriff as a character, every time a county ballot includes the sheriff's race. They are saying, in compressed and transformed form, the Anglo-Saxon Shire Reeve. The King's Man in the Shire, the medieval administrator of regional royal governance, the villain of Nottingham, the frontier lawman of the American West, all contained in 2 syllables that have crossed a millennium and an ocean and been transformed by everything they encountered, without ever losing the thread back to their origin. The Shire is gone, the Reeve is gone, the King is gone from American governance. But the sheriff is still there, still elected, still wearing the star, still carrying a title that an Anglo-Saxon administrator would recognise as his own, in a country that did not exist when the title was invented, and that built its entire political identity on rejecting the kingdom whose administrative system produced it. This is, in its small and specific way, a perfect example of everything we have been talking about in this entire video. The medieval thing that was meant to be a practical administrative arrangement for a specific historical moment. The accumulation of institutional history that made it durable beyond its original context. The transportation across time and distance and political transformation that changed everything about it except the essential thread. And the persistence into the present of something whose medieval origin is invisible in its daily use, hiding in plain sight in the language and the institution and the star-shaped badge of the county sheriff. The Middle Ages really do get everywhere. Conclusion. The Middle Ages are hiding in your Tuesday, and here we are. At the end of a journey that has taken us from 11th century Bologna to the square mile, from the archery butts of a medieval village to the floors of modern parliaments, from the sanctuary knocker of a medieval church to the asylum law of a 21st century refugee convention, from the mortgage as theological workaround to the mortgage as the most consequential financial document most people will ever sign. What emerges from all of this, I think, is a picture of history that is considerably less tidy than the narrative of progress and replacement that we often carry in our heads. We tend to think of history as a sequence of eras, the ancient world replaced by the medieval replaced by the early modern replaced by the modern, each era comprehensively superseding what came before it. The printing press replaced the manuscript, the Industrial Revolution replaced the agricultural economy, the democratic state replaced the feudal hierarchy. And all of that is true, in broad outline. The manuscript is not coming back, the feudal hierarchy is not coming back, the specific social and economic world of the Middle Ages is genuinely gone. But the Middle Ages left deposits everywhere, in the words we use, in the institutions we inhabit, in the laws that govern us, in the procedures that organise our collective life, in the buildings we walk past and the units we measure things in, and the way we think about time and community and obligation and justice. These deposits are not nostalgic remnants, preserved because people are sentimental about the past. They are functional survivals, things that kept working, kept solving problems, kept serving purposes well enough that replacing them never quite became more attractive than maintaining them. The university that trained you, if a university trained you, is a medieval institution. The legal system that protects your rights, if your legal system is a common law system, is a medieval institution. The jury that might, in certain circumstances, determine your fate, is a medieval institution. The mortgage on your house, if you have one, is named after a medieval legal concept. The grades on your degree, the gown you wore if you graduated, the terms that structure the academic year, medieval. The licensing laws that govern the pub where you might have a drink, medieval in their institutional logic. The postal service that still, improbably, exists, medieval in its origin. The local council that maintains your streets, medieval in its parish roots. The Middle Ages are not a museum. They are not a theme park or a period drama or a collection of castles that tourists visit on weekends. They are, in substantial and often invisible ways, the infrastructure of the present, the accumulated institutional solutions to recurring human problems, built by people who were working with the tools and the knowledge they had, intended for the immediate circumstances of their world, and proven durable enough across the centuries to still be here when you and I arrived. The next time you sit in a lecture hall, or sign a legal document, or read about someone claiming asylum, or hear the clock tower strike the hour, or receive a letter or drink a pint in a pub with a name that includes the word inn. The next time any of these things happen, you are touching the Middle Ages, not metaphorically, directly. through an unbroken institutional thread that runs from the medieval world to the present without ever having been cut. History, it turns out, does not always end when the history books say it does. Sometimes it just gets very quiet and puts on different clothes and keeps showing up to work. Thank you, genuinely and warmly, for spending this time with me. If this journey through the medieval things hiding in your Tuesday has been worthwhile, if you have learned something, or smiled at something, or looked at a familiar institution with newly curious eyes, please consider subscribing. It truly means everything to me. And leave me a comment telling me where you're watching from and what time it is. I am always astonished by the places these videos reach, and every comment reminds me why it is worth doing this. Sleep well, dream of something medieval, and remember that you probably already did, because the bed you're lying in is in a room in a building in a city organised around institutional logic that a medieval person would find, in its basic structure, entirely recognisable. See you next time.